here. Welcome to our live podcast. Today is another beautiful Wednesday, and thank you for joining. Today, before we go on, please invite your friends, family, colleagues at work, because we are discussing a very important topic today, which is Visa Bulletin. We are discussing this topic based on the enormous number of questions that we always receive regarding Visa Bulletin. A lot of people don't understand how Visa Bulletins work because this is something that affects every type of petition, including family-based, employment-based. Every single petition is affected by Visa Bulletin. So a lot of people don't understand this. And this is one of the reasons why some people have approved petition without being able to apply for green card, and they don't understand why. So that is why we have decided to discuss that issue today. So Visa Bulletin. This is a continuation of coming to live and work in the United States series that we are doing today. And I believe today's episode is this part what now? Part 5, 6? Part 6 of coming to live and work in the United States. So we are discussing Visa Bulletin. So if you have questions regarding Visa Bulletin, send in your questions as we will be discussing it extensively today. So now, what is Visa Bulletin? With the exception of immediate family, every single avenue for applying for green card in the United States have numerical limits. There are numerical limits set by the Congress. It is not an open check. Every single category have numerical limit. So the entire employment-based category, the numerical limit is 140,000 per year. In other words, immigration or the Department of State cannot issue more than 140,000 green card per year for the entire employment-based category. When we say employment-based category, that includes EB1, EB2, EB3, EB4, and EB5. All of them together, immigration cannot issue more than 140,000 green cards per year. So now, how is this 140,000 shared among all the 5 categories of employment base? These are the things that the Visa Bulletin determines. It is the Visa Bulletin that tells us every month how much of this 140,000 have been used, how much is available, where each person is, each applicant, where they are on the queue. So it is the Visa Bulletin that provides all this information every single month. The same thing is applicable to family-based petitions. Family-based category 1, family-based category 2, family-based category 3, family-based category 4. All this together, immigration can only approve 226,000 green cards in that category per year. So this 226,000 is shared among all the family-based category with the exception of immediate family. So some people will file for their US citizen, may file for their child or children who are unmarried but are adult over 21. It is this Visa Bulletin that will determine how long this type of application is going to, this type of applicant is going to stay on the queue. It is this Visa Bulletin that tells us where they are in the processing. It is the Visa Bulletin that tells us the number that has been approved per year and how many are remaining. It is the Visa Bulletin that tells us who applied first and where they are on the queue, in the line. So that is why Visa Bulletin is very, 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 very important in the adjudication process. Some people file for their married children and they are wondering, their application has been pending for 5 years, nothing has happened. Why do we have all this delay? It is because of the Visa Bulletin. So when we are discussing Visa Bulletin, it is a very, very important topic. And like I said, while I'm explaining the preliminary issues regarding Visa Bulletin, if you have questions, please continue to send it in. Now, in the family-based category, there are two categories of family-based petitions. We have immediate family. Immediate family of a US citizen. I've said it over our podcast over and over and over again that the way immigration law defines a family is different from the way English dictionary defines a family. So, as far as immigration law is concerned, immediate family of a US citizen is limited to the parents, the spouse, and minor children under 21. That is the definition of immediate family. Now, the reason this definition is important is to let you know that immediate family is not affected by Visa Bulletin. Immediate family is the only category that is not affected by Visa Bulletin. There is no numerical limit when it comes to immediate family. In other words, if 1 million US citizens decide to marry for a foreigners, all applications will have to be treated. There is no waiting time. There is no limit to the number of applications that immigration can attend to. If 1 million US citizens decide to petition for their parents, immigration will have to adjudicate all the 1 million petitions. There is no numerical limit. There is no limit to the number of green cards that immigration can process in that category. If 1 million US citizens decide to petition for their minor children who are under 21, there is no limit to the number of green cards in that category that immigration can process. So all these applications will have to be processed immediately. So that is why it is called immediate family. Now, once we go to the B part, which is extended family for immigration purpose, that is US citizen petitioning for unmarried child who is 21 and over, or US citizen petitioning for married child, or US citizen petitioning for siblings, brothers and sisters, or permanent resident petitioning for immediate family, or permanent resident petitioning for unmarried child. All of these things, they have numerical limit. They cannot go, immigration cannot issue more than 226,000 green cards per year in all of these categories combined. So that is why it is important to understand what Visa Bulletin is, because Visa Bulletin is what determines where immigration is in that process. If immigration can only issue 226,000 green cards per year for the entire extended family category, now, how do you know where you are on the queue? Maybe immigration received 50,000 application in the category of US citizen petitioning for unmarried child. Because immigration cannot approve 50,000 green card for that category, they have to prioritize it. In other words, the day each application is received, that day is what is called priority date. If your application was received on July 31st, 2024, that is your priority date. That is the date you join the queue. Now, other petitions or applications that were received before you, they take priority over your own case because they receive their own application before you. But how do you know when it gets to your turn? That is exactly what Visa Bulletin is all about. It is the Visa Bulletin that tells us every single month where you are in the application process. Because immigration cannot process all the application received, so they have to let us know, okay, where are you this month? So that is when they tell us, okay, for this category, maybe FB1, family-based category 1, US citizen petitioning for married child, this is where we are as at July 2024. Maybe married children of a US citizen, the Visa Bulletin is the one that will tell us this is the application that immigration is processing currently. Now, maybe US citizen petitioning for siblings, it is the Visa Bulletin that will tell us this is where the application is right now. So you look at the date that your own application joined the queue, which is the priority date, and you go to look at the Visa Bulletin to see where is immigration currently processing right now. So if they have not gotten to your turn, then there is nothing anybody, including immigration themselves, there is nothing anybody can do. So that is why people wait for years and years and years. And because a lot of people lack understanding of this Visa Bulletin process, they keep calling us, they keep asking questions. Oh, I filed for my son since 7 years ago. We have not had anything. They have not done anything. What is going on? Is immigration not processing my application? Is this? The immigration cannot do anything until they get to your turn on the Visa Bulletin on the priority stage. So if the current processing time is about 10 years, if your case was received in 2015, for example, that is less than 10 years. So they are not going to call your son or anybody. You are not even going to be able to apply for green card until they get to your turn, which is called Visa Bulletin. So it is the Visa Bulletin that will tell you when your case is current. When the Visa Bulletin is current, it simply means now it is your turn. You can go ahead and submit your application now. If you are physically in the US, that is when you can apply for green card. If you are outside the US, that is when you can start the immigrant visa process by submitting the fees for immigrant visa. Naturally, for people who are in the US, immigration may not contact you to tell you that it is now your turn. So it is your own responsibility to understand this Visa Bulletin, to understand the priority process, to understand and know when it is your turn so that you can apply for green card. But when your applicant or your son or daughter or your family member, when they are outside the US, because that process is conducted by the Department of State, National Visa Center, they are the one that will contact you. They are the one that will notify you to let you know that it is now your turn. Go ahead and pay the immigrant visa fee, which is the first step in the process if you have an approved petition. However, a lot of people, one of the major challenges that we see in this category is that because many of these classes of petition, because they take several years, we see a situation, especially those who file the petition pro se. Pro se meaning that you didn't involve a lawyer. Now, if you file the petition maybe 5 years ago, maybe at that time you are living in a particular address and now you have moved. Remember, immigration, they are no magicians. So when visa becomes available, the Department of State is only going to contact you through the address they have on record. So if they send a mail to you to let you know that visa is now current for your category, go ahead and pay the immigrant visa fee. If you did not do a change of address and you did not notify them of your new address, if they are not aware of your new address, they will only send the letter to the last address known in their record. And if for any reason you miss it and you didn't see it, unfortunately, there is nothing anybody can do about it. Now, that takes me to another point which I want to explain, and I hope that my listeners will understand. Now, the Department of State, they have a policy. It's not even a policy, it is the law. The law is that if you, once the visa bulletin gets to your turn and they notify you that it is now your turn, if you don't take steps within 1 year, if you don't contact the Department of State within 1 year, they will go ahead and send you a notice of cancellation, because they can't keep this thing indefinitely for you. Remember, there are thousands and thousands, hundreds of thousands of people waiting in line. So when if they get to your turn and they gave you up till 1 year and you didn't contact them, they will cancel the application. Now, before they cancel, they will give you a notice that, look, we have not heard from you in the last 1 year. We are going to cancel this application. If you have a legitimate reason why you didn't contact us, provide that explanation. If they believe that your explanation is valid, then they will reinstate the application. However, if they send you that notice that they have not heard from you in the last 1 year and you still didn't respond, if they wait the second year and they didn't get a response from you, if they go ahead, and destroy the petition and cancel the petition, there is no legitimate way. In fact, even there is no illegitimate way. There is no way at all to bring it back to life. Once the petition is cancelled, that is the end of the petition. For you to do anything about it, you have to start the process all over again. It doesn't matter how many years you have been on the queue. Once the application is cancelled, that is the end. The law does not make provision for a way to have it reinstated after that second year notice was provided to you. And like I said, whether you get it or not is immaterial, because it is your responsibility to notify USCIS, to notify them of your address. If your case has already been approved, if the petition has been approved and your case is forwarded to National Visa Center, waiting for visa bulletin to be current, if you move and you notify USCIS, that notice will not get to your file, because if your case is consular processing, USCIS will have forwarded your file to the Department of State National Visa Center. So at that stage, if you move, you are required to notify the National Visa Center, not USCIS. So if you send notice of your new address only to USCIS, you may still be in jeopardy, because National Visa Center may not update your address and they may keep sending notices to the previous address they have. These are some of the benefits of having a lawyer. Generally, when you have a lawyer, these notices will be sent to the lawyer, and it is very, very unlikely that any lawyer will move without doing a proper change of address. It is very, very unlikely that lawyers will not know how to notify either the USCIS or the Department of State about a new address. So these are some of the benefits. We have seen situations where people come to us after the case has already been terminated. Unfortunately, there is no provision in the law to reinstate a case that has been terminated and the record has been destroyed. I see that questions are already coming in, so I hope the questions are regarding visa bulletin that we are discussing today. What's this? Sushi, God bless you. Banapa, India. Is that a question or just a greeting? Okay. Okay. The first question. Good afternoon and thank you for joining. Okay. This is from us. Okay. Question. Thank you, sir. I'm currently looking at the visa bulletin. What is the difference between the final action date, the first chart, and the date for filing, the second chart? That is a very, very good question. Final action date applies to people who are physically present in the US. That is the final action date. Then the date for filing, that applies to people who are applying from outside the US. So in other words, if you are petitioning for your child who is 21 and unmarried, and then if that child is in the US, so you keep checking the visa bulletin and you look under the final action date because you will be applying for adjustment of status in the US. Excuse me. On the other hand, if your son is outside the US, you will keep looking at the filing date for filing because when it is current, you will be applying for green card from outside the US. So that is the difference. Final action date are for people who are physically present in the US, while date for filing are for people who are outside the US. The next question, receive our text message. I noticed there are two different bulletins for family based. The dates are different. If I'm present in the US, which one should I consult? Well, I think that question is the same as the one I just answered. So just consult the one that says final action date. If you are in the US, you go with final action date. If you are outside the US, you look at the one that says date for filing. The next question. I have an I-130 approved and currently present in the US and waiting for a visa to apply for green card. Can I get work permit while waiting? No, you cannot get work permit because work permit is attached to application for green card. And because you are not even able to submit that application, so you cannot apply for work permit. So when we are talking about work permit, it is something that is attached to application for green card. So your work permit, your travel document, all these things are attached to your application for green card. So because you cannot file the application until visa becomes current, you cannot get work permit based on that petition. The next question. If my petitioner status changes from permanent resident to citizenship while waiting a visa, can we update USCIS and how do I do it? Well, it depends on what you have pending. It depends on what you have pending, and it also depends on where your beneficiary is. Now, if, for example, you are a permanent resident petitioning for your spouse, while waiting for visa to become current, if you become a US citizen, then the action that you take will be determined by where the beneficiary is, where your spouse is. Let's say your spouse is physically present in the US. As soon as you become a US citizen, you don't need to notify anybody. All you need to do is to submit an application for permanent resident on behalf of your spouse. Because as I explained at the beginning, immediate family is exempt from the requirement of visa bulletin. Immediate family is exempt from numerical limitations. Immediate family does not have any form of restriction. So the moment you become a US citizen, your spouse, who is a member of your immediate family, You don't need to notify anybody. All you need to do, get your certificate of citizenship together, get application for permanent resident for your spouse, and then submit an application for permanent resident. You don't need to file a new petition. It is that same petition that you used when you are still a permanent resident that you will use, and the petition will still, the green card application will still be approved. Now, if your beneficiary is outside the US, this is when you need to update the Department of State. If your petition has already been approved, your petition will have been forwarded to the Department of State National Visa Center. Now, if you become a US citizen, you have to make a copy of your certificate of citizenship and send a letter to National Visa Center telling them that, okay, you have this petition pending on behalf of your spouse. You filed the petition when you are still a permanent resident. However, you are now a US citizen. Here is a proof that you are a US citizen. You attach a copy of your certificate of naturalization and request them to update their record accordingly. So immediately they receive it, they will take your petition out of the Visa Bulletin category. They will now treat your petition as immediate family petition. And of course, they will ask you immediately to submit immigrant visa fee, to submit immigrant visa application, to submit affidavit of support and the fees, and then they will start processing the application immediately. The next question. Question received via text message. Why do they separate Mexico, China, India from the rest of the world in Visa Bulletin? Very good question. As I stated, for extended family, because for family-based or for employment-based, there are numerical limits. And because there are numerical limits, they have to ration the number available. Now, there are some countries with very large number of immigrants. So those countries, include Mexico, India, Philippines, and even China. They have large number of immigrants. So these countries are treated separately, because if they don't, they will use up the entire bulletin. For example, in the case of siblings of a US citizen, the Congress allotted only 65,000 green card per year that can be approved. So imagine the number of siblings application being filed annually. Imagine the number of Mexicans who are US citizens who are filing siblings application for their siblings. So the issue is there's only 65,000 available. So if they don't ration it, that 65,000 may not even be enough for Mexico alone. So at the end of the day, other countries may have nothing left. So they have to treat them separately. Look, these countries with large number of immigrants, you cannot use up all these things. When it comes to employment based, India and China, they have more than every other countries. India has a lot when it comes to employment based. So if they don't treat them separately, India alone will use up all the available allocations. So in order to prevent inequity, in order to ensure that there is equity, that is why they treat countries with large number of immigrants separately. If you look at lottery, DV lottery, you will see that from time to time, the US government will exclude some countries with large number of immigrants. It is for the same reason. If the Congress pass a law allowing 65,000 people to be given green card based on the DV lotteries, if you have some countries where almost maybe 20% of their entire population will apply. If they don't limit it, they will use up everything. Excuse me. That is why there are some countries that are prevented from participating in the DV lottery. Excuse me. It is to prevent inequity. It is to prevent injustice. It is to ensure that this thing is spread around equally among all the nations. So that is why those countries are treated separately. Remember, India has a population of almost 2 billion. And I think China too does the same thing. So that is why those countries are treated separately. The next question, received via text message. How do I know that my category is in the Visa Bulletin? Well, I've explained it. There are 5 categories of employment-based petition: EB1, EB2, EB3, EB4, EB5. All employment-based petitions are in the Visa Bulletin category because each one of them have limitation. All of them combined, immigration cannot approve more than 140,000 green cards per year. So these 140,000 green cards are shared among the 5 different categories. So all of them are affected by the Visa Bulletin. Even though EB1, for example, they don't use it up because whatever allocation is given to EB1, because the requirement of EB1 is extremely high, very few people can meet the requirement. So usually they don't finish their allocation. Out of the 140,000, I think EB1 is allocated 26% or 27%? Can you please help me confirm? I know it's 20-something% that EB1 were given. So that 20-something%, how many people can meet that very, very high requirement of EB1? So they usually don't finish it. Okay, 28.6%. So they usually don't finish it. But if you look at EB2 on the other hand, EB2 is also given 28.6%. But guess what? That 28.6% is not even enough. Then talk of EB3 is even worse because they have more applications in that category. So it takes longer for EB3 for visa to be current in the EB3 category. However, when you go to EB5 is another thing that is for investors. It requires someone to invest $800,000. So by the time you add all other expenses, administrative charges, attorney's fees, filing fees, you'll be looking at over $900,000 or at the minimum $900,000. So how many people can afford $900,000? In fact, to be honest, those who can afford $900,000 in their own countries, they are probably not going to relocate to the US. So these are the categories that people don't use up annually. That is why when you check the Visa Bulletin, EB1 and EB5, they are always current. Because
except for China and India.
Yes. So EB1 and EB2, but even for China, EB1 is current. It's not?
I just checked it.
Oh, okay.
Yeah.
And EB5 too?
Correct. Yeah. EB5. Yeah.
Okay. So I've just been told that even for China and India, EB1 and EB5 is not even current. Again, like I told you, these are countries with billions of people. So it's going to be much easier to see people who will qualify from this country. So they treat them separately and differently. So That is why that happened. Where's the last question? Okay, I think the question I was answering is the one that said, how do I know what category is in what my category is in the visa bulletin? So the way to know that, is that the question I was answering?
The one above it about Mexico, China, and India being separated from the rest of the world.
Okay. So the next question received via text message. How do I know what my category is in the visa bulletin? Well, I think I explained that earlier. When you submit your petition, the date that immigration received your petition, that date is what is called priority date. Now, if your petition is employment based, the date you file the I-140 petition or the date that you file your labor certification, that is what is called priority date for employment based. If it is family based, the date you file your form I-130 petition for alien relative, that is the date that you join the queue. That is your priority date. So all you need to do, you open the visa bulletin, you look at your category, whether you are within the category of US citizen petitioning for married child, whether you are in the category of US citizen petitioning for married child, whether you are in the category of US citizen petitioning for siblings, whether you are in the category of permanent resident petitioning for immediate family, whether you are in the category of permanent resident petitioning for unmarried adult child, whether you are in the category of employment based, EB1, EB2, EB3, EB4, or EB5, whatever the category is. So you look at the category on visa bulletin and you look at the date that immigration received your application. That date is your priority date. So the visa bulletin will tell you the date that immigration is currently processing. So that is the date, that is when you know. So if the date on your application is earlier, is the same date or earlier than the date that your application was received, then it means that visa is current for you. But if the date on your receipt notice is farther than the current date published, then it means they have not gotten to your turn. The next question. If my green card application was approved, but then the final action date for my category and country later retrogresses, does that affect my status as a lawful permanent resident? No, it does not. Even if it was approved in error, you are just lucky. No, it does not. Once you have your green card, you have your green card, nothing else. Especially if the mistake was not from you, it doesn't affect your green card in any way. The next question received via text message. How often is the visa bulletin updated? It is updated every single month. The visa bulletin is updated every single month. And let me say this, visa bulletin, the date that immigration is processing or the Department of State is processing, that date can go forward and it can also go backward. So it is erroneous to assume that, oh, maybe your application was received January 15, 2015, and then you check the visa bulletin last month, you see that they are currently processing December 15, 2014. So you are thinking, oh, by next month they are going to get to my turn. Yes, next month they may get to your turn, but next month they can also go back to October 2014 because it moved forward and it also moved backward. That is what they call retrogression. When it goes backward, that is retrogression. What can cause that? Let me explain what can cause retrogression. It depends on the number of applications received in any particular month. For example, let's say in the category of US citizen petitioning for adult unmarried adult children, let's say in October, immigration received 50,000 applications. Now, all the 50,000 applications are going to be on the queue. They are going to be given receipt number, priority date, and they all join the queue. Now, if by the following month, November, let's say immigration received only 10,000 applications in that category, definitely, because the number of applications received is very low, the visa bulletin will move forward more quickly. On the other hand, if by the following month, if immigration received 100,000 applications, maybe all the ones that are supposed to file previous month, they didn't file, everybody now file together in the upcoming month, and now immigration received 100,000 applications, the visa bulletin is going to retrogress. So those are the factors that nobody can predict, not even immigration. Immigration does not have a way of predicting, okay, this July we are going to receive 10,000 applications. They don't have a way of knowing that. They cannot predict that, okay, by August, this is how many applications we are going to receive. They don't have a way of knowing that. So those are some of the factors that affect the visa bulletin, because irrespective of the circumstances, irrespective of what led to increase or decrease in the number, the visa bulletin cannot change. The numbers allocated by Congress cannot change except there is a law passed by Congress to either increase or decrease the number. But for as long as that has not happened, there is no way of determining how many applications will be received in any particular month, or determining whether visa bulletin will move forward or will retrogress backward. The next question, received via text message. I noticed visa bulletin shows they are working faster on the category of spouses of permanent residents than spouses of US citizens. I just naturalized, but I don't want to change my status because that will delay my spouse case more. Will this bring any consequence? Well, it's a risky situation. It's a risky situation because if your spouse is not in the US, as I said, it is your responsibility to notify the National Visa Center. So if you don't notify them, they may not know that your status has changed. And of course, you can continue to process your application as that of a permanent resident. However, if you notify them, it is important and it is mandatory by law that they will have to change the category from a permanent resident petitioning for spouse to a US citizen petitioning for spouse. But let me tell you this, if you are petitioning for your spouse, to be honest, updating your status as a US citizen will actually help your case. It's not going to work against you. It's going to help your case, because now if you become a US citizen, your status become immediate family of a US citizen, which is given priority. So you don't have anything to lose by notifying them. In fact, by not notifying them, you stand the risk of being accused of misrepresentation in the future. Although I don't see how that affects the application, because like I said, notifying them only give you an advantage. It doesn't give you any disadvantage. So if you become a US citizen, you notify them, your application change to immediate family of a US citizen, and you receive priority. So you don't have anything to lose by notifying them. The reason that the applications for spouses of permanent residents, the reason that they move faster is because a lot of permanent residents, while they are waiting, they become US citizens, and then they just change the category. So those people are taken off of the queue. So that is why that category move much faster, because as people become US citizens, they get out of the queue. They become US citizens, they get out of the queue. So that is why that category move faster. However, if you become a citizen, like I said, it doesn't give you any disadvantage. So it's better to just notify them. But my suspicion is that this person is actually maybe trying to talk of a permanent resident petitioning for unmarried adult child. But even if that is still the case, it is still better to notify them, because not doing so may work against you in the future. So you don't have anything to lose by notifying them. Notifying them that you have become a US citizen does not in any way delay your application. It will actually help it. The next question. I have an approved NIW petition. My priority date is later than what is on Visa Bulletin. My OPT is about to expire. What can I do if my OPT expires before they reach my priority date? Well, you have to find a way to keep yourself in status, because employment based is very, very strict. It's different from family based. For family based, if you are out of status, you may still be able to get it. But for employment based, they are extremely strict. You have to show that you are maintaining lawful status until the date your application for permanent resident is submitted. So if visa is not current for your category and your OPT is about to expire, apply for a change of status or an extension of status. Find a way to keep yourself in status. If you are on F1, go back to school. Find a way, especially now that you already have an approved petition. Just find a way to keep yourself in status until they get to your turn, because if you are out of status, you are going to lose the benefit of that petition. No matter the degree you have done, even if you have completed your PhD, you can still go back to register for another course. Just find a way to keep yourself in status. Or if you find an employer and you have the opportunity to apply for H1B, you can also do that. But you have to keep yourself in status, because every single employment-based petition requires the applicant to be maintaining legal status as at the date of application for permanent residence. The next question received via text message. If I file for my siblings, whenever their time comes, can they bring their children with them? Oh yes, if you file for your siblings, that will be under F4 category, US citizen petitioning for adult siblings. Adult US citizen petitioning for siblings. Yes, as at the time your visa is current, once visa bulletin is current, they get to your priority date. If your sibling is married at the time, all you need to do is to notify USCIS that your sibling is now notify the Department of State, National Visa Center, that your sibling is now married. That is assuming that he or she was not married at the time the petition was filed. So notify them. They will send you an invoice for you to pay the immigrant visa fee for your sibling. If your sibling now have children which they didn't have at the time you file your petition, all you need to do is to notify the National Visa Center that your sibling now have children and submit the birth certificate of those children. In the case of marriage, submit the marriage certificate, and then the National Visa Center will send you an updated invoice asking you to pay the immigrant visa fee for them. But yes, your siblings, children, and spouses can be included. They are all covered by the same petition without you having to start all over again. Yeah, the only thing when it comes to the children, the same way that age immediate families are defined, your siblings' children, they have to be under 21 in order to qualify as immediate family. So if they are over 21, they will not be included. So they have to be under 21 at the time that you apply for the application. The next question. Question received via text message. Why do dates in Visa Bulletin retrogress? And I think I've answered this question before. The reason it retrogresses is because the number of petitions received at any particular month, they vary from month to month. Sometimes immigration receive less applications. Sometimes they receive more applications. Usually when the month that they receive more applications, Visa Bulletin will retrogress. The month that they receive less applications, Visa Bulletin will move much faster. And the month that receive an average of the same application, Visa Bulletin will move at the normal slow speed that it does. So the number of applications received in any particular month determines whether Visa Bulletin will move forward or retrogress. The next question. How does retrogression of the final action date affect eligibility for exemption from the 6-year limit on H-1B? Retrogression does not affect eligibility for H-1B. The only thing that affects eligibility for H-1B is labor certification, permanent labor certification. H-1B is valid only for 3 years. It is renewable for another 3 years. So the maximum anybody can be on H-1B is 6 years. However, if a labor certification application was submitted before and has been pending for at least 1 year before the expiration of the 6 years and is still pending, then the USCIS can continue to renew H-1B for in increment of 1 year until they approve it. However, where the application, the I-140 immigrant petition for alien relative, if that application has been pending for at least 1 year before the expiration of the 6 years on H-1B, again, an applicant can also use that to apply for a renewal of the H-1B beyond the 6-year limit. So it is not what was that? So it is not the retrogression. It is not the retrogression of the final action that can lead to extension of H-1B beyond 6 years. It is actually the pending application for labor certification or pending application for immigrant visa, like the I-140 petition. If those petitions, either of those petitions, have been pending for at least 1 year before the 6th year on H-1B, that is what allow an applicant under AC 21 to be able to extend the H-1B beyond 6 years. The next question. Why does USCIS not allow non-citizens to apply for adjustment of status based on the date for filing chart every month of the year? I'm not sure I understand this question.
Like how they let some months they let you use the ones that are for consular processing, but for adjustment of status.
Oh, okay. So the question is asking why there is a difference between filing visa filing application and people who are here. Is that what the question is asking?
Sorry,
Why not allow them to use the visa application date instead of the final action date? Okay, the reason for that is that those who are physically here in the US, the moment they submit their application, they are able to apply for employment authorization right away. They are able to start benefiting from the application process. Whereas for those who are going to do the visa application, they are still going to spend a lot of time processing it. They are not going to have any benefit. So in order not to give those who are here any advantage over those who are outside, that is why they allow those who are outside to start the application process first. At the end of the day, when you look at it, those who are here are still going to benefit even much faster, because if somebody is here, the moment you submit application for adjustment of status, you are able to submit application for work authorization, you are able to submit application for travel permit, you are able to work, you are able to get social security number, you are able to go in and out of the country. So you start enjoying the benefit immediately. But somebody who is applying from outside, they cannot even enjoy any benefit until the end of the process. So they are disadvantaged. So in order to, one thing with immigration, they strive to create a balance, to try to create equity among the different classes of people. So they just believe that, okay, since these people are outside, it's still going to take them several months, because sometimes you may still be at the National Visa Center for up to 1 year, or in some cases more than that. By the time you are done with the National Visa Center, you still have to go to the embassy. So I mean, in this office, we have cases that have been documentarily complete since 2022, and yet we don't even have interview date. So imagine if those people are physically in the US, they will have gotten their green card. So it's a lot of benefit for those who are here, and that is why they allow those who are outside to start the process earlier.
But then, some months they do let us use the other dates.
That one, okay. The question is, sometimes the visa bulletin allows, in limited situation, those who are here to also use the visa application date. Like I said, immigration, every time they strive to create a balance between all these categories of applications. When they see that in a particular category, the number of applicants who are outside, they are much less than the number of applicants who are inside. So, and they see that allowing the applicants who are inside to use the visa application date will not create any unjust situation for those who are outside, then they allow it. Remember, they have access to know how many people are applying from outside, how many people are applying from inside. We don't have access to that information. So when they see that those who are inside are much more, maybe they have about 50,000 waiting inside, maybe those who are outside, they are probably 1,200. So in some cases like that, they allow they allow those who are inside to use the visa application date. But when that happens, they will state it in the visa bulletin. When they release the visa bulletin for that month, they will tell you that, okay, those who are inside, they can actually use the visa application date to submit an application inside the US.
So the number of visas available for the ones that are abroad will decrease because they're going to assign them to the ones here? Do they allow that? Or they keep the same number of visas available for them over there?
No, they will have looked at the prevailing number for that particular month and realize that, remember, for those who are outside, they are still going to go through the National Visa Center, they are still going to go through the embassy. So they may realize that withholding it is not going to add any value. So at the end of the day, that month, there may be unused visas. So rather than allow unused visa situation, it's better to allow those who are inside to use it for that month. The next question. I filed for my spouse as a permanent resident when visa was current. She filed for green card too, but then visa bulletin retrogressed and now no visas are available. What's going to happen? Will they deny her? No, they cannot deny her for as long as visa was current at the time that you filed the application. They will not deny her. They will only keep the application until the visa becomes available. When visa becomes available, that is when the application will be approved or adjudicated. But they cannot deny her. Once the application is received, whether they accepted it wrongly or rightly, for as long as at the time you submitted it, it was current. Even if it retrogress after, you are already in, they will not deny it on that basis. But they can still deny it if your spouse was not in legal status, because that is one of the differences between a US citizen petitioning for a spouse and a permanent resident. In the case of a permanent resident, your spouse has to maintain legal status. So they can deny it on that basis, but they cannot deny it on the basis of retrogression. The next question. I'm from Mexico. My spouse is from Nigeria.
This one for Clifford Lambert.
Oh, R1, any update? What do you mean by any update? There's nothing wrong with R1. Yeah, they just need to check the, for R1, just check the visa bulletin. That is under EB4. EB4. Check the visa bulletin under EB4. So you will see the status of where they are. The next question. I'm from Mexico. You can help me check the chart for EB4, religious workers, so that we just give that information to this person. The next question. I'm from Mexico. My spouse is from Nigeria. They are currently on my priority date for all chargeability areas except those listed, but not for Mexico. I heard about something called cross chargeability. What is that, and how will it benefit me? Well, it cannot benefit you because cross chargeability is for those who have dual citizenship. Oh,
They use the spouse and they can use the spouse's country sometimes.
Yeah, not in the case of Mexico, because the reason visa is not current is to prevent undue advantage. The only time in this case is if your spouse is from Nigeria, you can apply for Nigerian citizenship. Let me tell you this. This may come as a shocker for Nigerians who are listening to this podcast. Do you know that in Nigeria, we also have green card? So, file an application for green card. Nigerian green card for your Mexican wife. Let your wife go through the process of becoming a US citizen, a Nigerian citizen. So if your spouse becomes a Nigerian citizen, you can now change your category from being application from from Mexico to Nigeria. That is one situation that I know that you can change the chargeability. I believe this is the last question. Were you able to get the visa bulletin for the religious?
Got distracted by that question.
So I believe that is the last question for today, but I want to get the update on religious applications.
January 1st, 2021.
That's the priority date for they should have released August right now.
Yeah.
That's for August 2024. Okay. For religious petitions, they are currently processing cases received on January 1st, 2021. So that is where they are right now on religious applications.
For the dates for filing for consular processing, it's February 1st, 2021.
That is for those who are here, but those who are outside, they are in February 2021. Okay, I believe that is the last question, and in the absence of any new question, we will have to be ending the podcast today. Again, remember to invite your family, friends, colleagues. Remember to join our podcast. It is 12 p.m. every Wednesday, Central Standard Time. That is 12 p.m. Dallas time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific. And that is currently 6 p.m. Nigerian time. So remember, the only thing you can do to show appreciation to all these things we are doing is to let other people know about it. Because the Bible says, my people perish for lack of knowledge. We are providing all this free information just to prevent avoidable mistakes. So what benefit will it be if you are receiving all this information and you are not sharing it? We are providing it free of charge. Please share it. Let others also know about all these things so that others too can benefit from it. That is the only thing you can do to continue to encourage us. Thank you again. We hope to see you. And I believe that we are continuing our coming to live and work in the US series. Do you know what the next topic is going to be?
It is humanitarian based. So
anyway, we will post the next topic. We will post it today before the end of the day so that people will know what topic we'll be discussing next week. Thank you again for joining us, and God bless you. This is Dr. Olu Asekun.